Kinsley, is it better that at the beginning?
I think it's still the
Oh,
might
yeah.
might not be able to see some part of you.
Okay, because at my screen it looks better. That's
Oh,
why.
it looks better.
Can the participants see and hear us already or not yet?
Yes, the participants are in the room. Yeah, they can
Okay.
see and hear you.
Yep. Thank you.
Hello, everyone. My name is Kingsley, and I will be your host for today. As your host, it's my privilege and pleasure to welcome you to this webinar on international arbitration in Central Asia. It's our privilege to be able to hear from speakers from Uzbekistan, Kazakhstan, and Kyrgyzstan on their perspectives in the growth of arbitration in their jurisdictions. Before we begin, let me introduce our esteemed moderator for today. Dmitry Marinkov is an in-house legal counsel and regularly acts as arbitrator in international commercial cases. He has participated in more than 30 international arbitrations under various rules, including appointments as co-arbitrator, sole arbitrator, and presiding arbitrator. A fellow of the Asian Institute of ADR and the Chartered Institute of Arbitrators, Dmitry is included in the list of arbitrators of the Hong Kong International Arbitration Center, Asian International Arbitration Center, Thailand Arbitration Center, and other institutions. Dmitry Marinkov is a member of the AIADR editorial subcommittee. He has published on international arbitration and appeared as speaker in conferences. Mr. Dmitry, the floor is yours.
Thank you very much, Kingsley, for the kind introduction. Welcome, everyone, and thank you for joining. A few words on the topic of today's webinar. Central Asia comprises 5 countries, which is Kazakhstan, Kyrgyzstan, Tajikistan, Turkmenistan, and Uzbekistan. The region stretches from the Caspian Sea in the west, China in the east, Russia in the north, and Afghanistan and Iran in the south. For quite some time, the region didn't have the necessary focus. There weren't too many publications or events on the topic. However, Central Asia is now increasingly getting attention from the international arbitration community. Not surprising to me, given its economic potential, its natural resources, its geographical location, and also interesting legal developments. And talking about international arbitration, the region is both relevant and of interest for commercial and investment arbitration. And our today's panelists will tell us why. Let me please introduce our today's speakers. Our first speaker will be Ms. Natalia Alenkina, who is an associate professor at the American University of Central Asia, located in Bishkek, Kyrgyzstan. Natalia has an extensive experience as arbitrator, as legal counsel, and as expert in Kyrgyz law. Since 2019, Natalia Alenkina has been a member of the ICC court and since last year, an ambassador of the Vienna International Arbitral Center. Natalia is a member of the Scientific Advisory Board of the Supreme Court of the Kyrgyz Republic. She is accredited by the Kyrgyz Ministry of Justice as a legal and human rights expert. She took part in the development of the Civil Procedure Code and the law on mediation in Kyrgyzstan, and she's a co-author of commentaries on the Kyrgyz Civil Code and Code of Civil Procedure. Welcome, Natalia. Our second speaker will be Bahit Tukulov, who is a partner at the law firm Tukulov, Kastilgov, Shaikenov Litigation Arbitration in Almaty, Kazakhstan. He represents clients in a large number of high-profile cases in commercial disputes concerning Kazakhstan and Kazakh law. Bahit has also significant experience as an arbitrator in Kazakhstani arbitration institutions. He frequently acts as an expert in cross-border litigation and arbitration proceedings. He's recommended by Chambers and Partners, Legal 500, and Who's Who Legal. He's a member of the Expert Advisory Commission under the Supreme Judicial Council of the Republic of Kazakhstan, and he is authorized to represent the interest of the parties in the AIFC court in Kazakhstan. Last but not least, we have Diana Bayzakova with us as a third panelist today. Diana is the director of the Tashkent International Arbitration Center, TIAC, located in Uzbekistan. Being a multilingual dispute resolution specialist, Diana acted as a sole arbitrator, chairperson, and co-arbitrator, as well as counsel in numerous international arbitration proceedings under a variety of different arbitration rules, including DIAC in Dubai, ICC, SCC Stockholm, and others. She's the only arbitration practitioner from Uzbekistan ranked by Legal 500 on the so-called arbitration power list, CIS and Caucasus. In 2020, Diana was appointed as an arbitrator to the ICSID panel of arbitrators. Diana is also the editor of the Oil, Gas and Energy Law Journal, which is published in the Netherlands. Let me say that I'm very pleased with the composition of our today's panel, because we have one academic who's also a member of the ICC court. We have an experienced litigation and arbitration attorney, and we have the director of the leading institution in the region. This allows us to view or to look at today's topic from various angles. And let me also mention that all three of the speakers regularly act as arbitrators. We have agreed that the speakers will make a brief presentation, a kind of an introduction to their jurisdiction and the current developments, followed by discussion. Please feel free to submit your questions via the chat, the Q&A session on Zoom. Please note that the webinar is being recorded, and the recording will be uploaded on YouTube afterwards. So please let us know if you don't want your name to be mentioned when asking questions. And without further ado, I will will give the floor to our speakers. Natalia, you're the first speaker, please.
Greetings to the participants of the webinar, and million thanks to Dmitry for the kind introduction and for an invitation to take a part in this wonderful discussion. Okay. I'm glad to present to you my country, which is famous to its picturesque mountains, landscape, ancient history, and amazing people. But today, I want to introduce the arbitration landscape of Kyrgyzstan, which is also very special. I will focus on the most significant features of the developments of commercial arbitration in Kyrgyzstan, both domestic and international. In particular, I will speak about the peculiarities of the commercial arbitration law, about the experiments with the arbitrability of public disputes in Kyrgyzstan, and lastly, about the interaction with state courts, and especially about setting aside of awards. First, and it is very important, in Kyrgyzstan, arbitration has the constitutional status. On the slide, you see the article of our constitution, and we have always considered this to be advantage and some kind of guarantee against the arbitrary evolution of arbitration as a method of dispute resolution in Kyrgyzstan. But these norms had played different roles in different times. At the dawn of their independence, the constitutional provisions that only citizens could establish arbitration court proved fatal for the first arbitration court established not by the citizens, but the Chamber of Commerce. And today, the constitutional provisions on the arbitrability of only civil disputes, only private disputes, are also constrained, expanding the competence of arbitration court. But I will focus on the last argument later. So moving to the legislation, Kyrgyzstan is a party of the New York and Washington Convention. And one interesting fact, 25 years passed between the ratification of the last, Washington Convention, and the completion of the ratification procedure. We became full participants of the Washington Convention only in the spring of 2022. Until now, all investment disputes in ICSID in relation to Kyrgyzstan could only be considered according to the additional facility rules. In terms of legislation, the law of the law on arbitration courts of Kyrgyz Republic was adopted in 2002. 1 year ago, we celebrated 20th anniversary of this law, and it's one of the most stable law in the legal framework of Kyrgyzstan. The law is designed for both domestic and international arbitration, although careful reading makes it obvious that it is mostly oriented for domestic arbitration. This is particularly evident from the provision of 5-day time limits for the making an award, or the strict requirements to the arbitration agreement. For instance, arbitration agreement without the exact name of the arbitration court is invalid. And the closed list of arbitrators. So you cannot appoint arbitrators in Kyrgyz arbitration court beyond this closed list of arbitrators. Thus, Kyrgyzstan does not have any law on international commercial arbitration, and the current one is more oriented for the domestic arbitration. Meanwhile, the Civil Procedure Code, which contains the provision about the recognition and enforcement of arbitral award, distinguishes procedures between the domestic arbitration award, foreign arbitration award, and international arbitration awards. The procedures and grounds for refusal to issue the writ of execution are different. So in the legal framework, we have 3 different terms: domestic arbitration, international arbitration, and foreign arbitration. But we have no any specific law about the international arbitration in Kyrgyzstan. Therefore, it seems to me that the legislation on arbitration should be amended to take into account the needs of the international arbitration. And it's interesting detail that 3 of our Central Asia countries have a different approach to these issues. I will be very interested to listen Bakit about the motive of Kazakhstan to finally adopt the one legal act instead of 2, because as far as I know, initially Kazakhstan also had different legal acts devoted to the domestic and international arbitration. And of course, the experience of Uzbekistan, because it's the only country which implemented the UNCITRAL model law in our region. Okay, so moving to the next question about the arbitrability of disputes, I would say that in Kyrgyzstan, the arbitration courts have fairly broad competence. They can consider any civil or any private law disputes. We have no any restriction on arbitrability of civil law disputes with governmental bodies, as for instance, our close neighbors have. No restriction about the disputes with consumers, corporate disputes, no restriction about the disputes under the joint agreements, etc. But from my perspective, the most interesting things in Kyrgyzstan are our experiments with arbitrability of public disputes. Recent tax code allows tax disputes to be arbitrated from the beginning of the last year. This development reflects the Kyrgyz government's ongoing efforts to rectify shortcomings in our judicial system by outsourcing administration of justice to the private institution. And the main characteristic of tax arbitration in Kyrgyzstan are the following. I hope you remember the constitutional limitation and arbitrability of only civil dispute, only private disputes. So in order to make tax or public arbitration possible, from the beginning of last year, tax relationships, which are public by nature, were called as civil or a private relation. This is such a rather controversial legal fiction in our tax code. Second, the taxpayer have no right to choose between, have right to choose between the arbitration and the administrative court. This choice, from my perspective, is rather unequal, as arbitration and administrative courts offer fundamentally different procedure for dispute resolution. Tax disputes do not require the arbitration clause. It applies to tax authority by default. And last, tax dispute can be resolved only by the institutional arbitration rather than, for instance, ad hoc arbitration, and only by the arbitral tribunal consisted of 3 panelists. I would say that it's not the first attempt to refer public or so-called administrative disputes to the arbitration. It has already been made in Kyrgyzstan in 2019. At that time, the law on public procurement was amended to allow the decisions of the procuring entity and the decisions of the complaint committee to be appealed to arbitration. In order to understand it correctly, it's not the disputes between the parties of the procurement contract. It is the lawsuits of losing party against the organizer of the tender. So it's the public disputes. The novelty ran for 4 years. It certainly generated a lot of interest and debates in our arbitration community. I know that some bidders were looking at the possibility of arbitration. However, no lawsuits were ever filed. The rule were eventually adjusted in last year, so now only disputes from the procurement contract are arbitrable. And the question about the interaction between the arbitration and the court. The interaction between the courts and arbitration in Kyrgyzstan consists of the enforcement of arbitral awards and interim measures for claim to arbitration. There is lack of court assistance in obtaining evidence, unfortunately, and that is unique. There is no procedure for setting aside arbitral awards in Kyrgyzstan. So in Kyrgyzstan itself, the absence of setting aside procedure is presented as an advantage. Just imagine an award, once it's rendered, can be challenged not only the merits, but also the procedural points. But just as there are 2 sides in the coin, there is an adverse side of this situation. The losing party is deprived of the right to active defense. Under Kyrgyz law, an arbitral award is only subject to control of Kyrgyz courts if the recognition and enforcement of award is sought in Kyrgyzstan. But if arbitral award does not require enforcement, or if the winning party for some reason does not file enforcement, the losing party cannot anywhere claim violation occurred during the arbitration. It can be invalidity of the clause, breach of the notice, or maybe improper composition of the arbitration. So in some aspect, it has an adverse effect, the absence of the setting aside procedure. But I would like to inform the audience that toward the end of the past year, our government initiated a draft law providing for a procedure for setting aside arbitration court awards. So now we are in the process of the huge discussion of this new initiative of our government. And my last couple of words I want to devote to the arbitration institutions in Kyrgyzstan. So there are 4 arbitration courts in Kyrgyzstan. You can see the names on the screen. And the first one, International Court of Arbitration under the Chamber of Commerce and Industry of Kyrgyz Republic, is one of the oldest and one of the prominent international arbitration court in Kyrgyzstan. It was established in 2002, so we also celebrated anniversary last year. And this court has a lot of cases in their active. You can see that nowadays they have more than 1,500 cases. 76 of them are international cases, and the parties represented more than 20 countries. Our International Court of Arbitration is very proud of his collection of articles. I invite all the participants of webinars to familiarize themselves with these articles. They are free access at the website of the arbitration court. You can see the name of the website, Arbitro.kg. And our last initiative, I also maybe a couple of words about it, following the common trends in the arbitration world. 1 year ago, International Court of Arbitration adopted the code of conduct of arbitrators and established the ethic committee, which considered complaints on the behavior of arbitrators. So that's all what I want to say during this short presentation. Thank everyone for your attention, and I am ready to answer the questions if there are.
Thank you very much, Natalia, for this good overview of the arbitration landscape in Kyrgyzstan. Let's look at Kazakhstan next. Bahit, the floor is yours.
Okay, if you give me a second, I'll try to switch to my screen. Okay, can you see?
Yeah.
Okay, great. Now let me. Okay, whatever. Kazakhstan is slightly more complicated jurisdiction compared to probably the rest in the region. Why is it complicated? In that we in Kazakhstan love copying things. You know, we don't want to devise things anew. We love copying. So our government has seen Dubai International Financial Center. So they saw how it worked. So they thought that they should copy the same thing to attract investments. So and it proved very successful, by the way. So we have two systems in Kazakhstan. Basically, the default system under Kazakh arbitration law, which was adopted in 2004, which has seen a lot of amendments. It's constantly being amended, but it's never a copy of the UNCITRAL model law. So we're constantly evolving and constantly moving towards the UNCITRAL model law, but we haven't arrived yet, and not clear when we're going to arrive there. So, but overall, there are no provisions in our arbitration law which are extremely unusual. Maybe some of the weird things involving the state, which I will explain a bit later. So the second system. So yes, and this Kazakh arbitration law system, it interacts with local state courts. So basically, like everywhere in the world, if you want to enforce a foreign arbitral award, you would have to seek enforcement through local state courts. If you want to recognize and enforce a Kazakh arbitral award, you would also do the same through the local state court. We have a second system where with this Astana International Financial Center, a constitutional law was adopted to basically modify our constitution to introduce this arbitration system and court. So basically, it establishes an exemption, a carve out from our entire legal system. And the system of Astana International Financial Center is based on the principles of English law, with English judges, about which I will also explain a bit later. So in terms of Kazakh arbitration law, so it applies to all arbitration seated on the territory of Kazakhstan. As I said, it's not identical, but broadly similar to UNCITRAL model law. There's a number of respected arbitral institutions in the country, but most of them work with domestic disputes. Kazakhstan International Arbitrage, we call it KMA. Another one is the arbitral institution with the Chamber of Commerce. They also hear disputes with foreign entities, individuals, but not that often, I would guess. The statistics is 86% of enforcement. But to be very frank, within those 14% of rejections, there might be probably largest awards. So the 86% statistics shows just by numbers, but not by the volume of or by the size of arbitral awards which are enforced. Recognition procedure is fairly quick, 15 business days, and you can get a judgment, a ruling of the district court, which can be immediately enforced, although you can appeal it further. submission of an appeal does not suspend enforcement. There is a caveat with respect to entering into arbitration agreements with state and companies related to the state, in which the state holds more than 50% shares. So you would basically have to obtain consent from, quote, higher ranking state authority, unquote. This is extremely rare to get such consent. So basically, it's just a way to maybe restrict state institutions from entering into arbitration agreements. So if you're entering into an arbitration agreement with the state, you need to be careful about that. So since relatively recently, motions to set aside domestic arbitral awards are heard by the appellate court, so it has become more difficult to set them aside. Unlike, I guess, the rest of the countries in Central Asia, we have private enforcement systems. So basically, we have licensed enforcement officers. It's like a business. They charge you a fee. So we have a business of enforcing money judgments. So and our enforcement system is extremely efficient and very competitive. So if you're not happy with one enforcement officer, you can terminate the contract with him and choose someone else. Now we go to AIFC legal framework. So the AIFC Court and International Arbitration Court of the AIFC are completely exempt from the general regulatory regime under Kazakh arbitration law. So basically, any of allegations of procedural irregularities or whatever, they are simply impossible because the local law does not apply. AIFC International Arbitration Center has its own rules and regulations, which are mostly based on LCIA rules. One of the most important feature of International Arbitration Center of AIFC is that it's supervised by the AIFC court, which is comprised of retired English judges. So basically, the risk that an arbitral award would be set aside is extremely, extremely low because English judges, as you know, they have a very pro-arbitration stance. So, the fact that AIFC court, which operates based on its own civil procedurals, which are very resembling to English civil procedure rules, so it gives you a lot of leeway in terms of gathering of evidence and obtaining injunctive relief, for example. So many of the options available in English courts in terms of gathering of evidence or injunctive relief, they're also available to support arbitration proceedings in the AIFC. So, for example, you could do document searches, you can do required discovery, you can obtain freezing injunctions. We recently obtained a freezing injunction, which is otherwise unavailable as a matter of local procedural law. So we basically obtained a freezing injunction, which covered a group of companies, not necessarily the defendant in the proceedings. Although AIFC International Arbitration Center has a list of approved arbitrators, there is no restriction to recommend or to choose an arbitrator from beyond the list. So you can choose anyone else. So in all other respects, it has proved to be very effective. Apart from AIFC International Arbitration Court, we also have the AIFC Court, about which I mentioned several times. One of the important features of AIFC Court is that apart from, in this penultimate paragraph, it lists the grounds for the AIFC Court's jurisdiction. So apart from the rest of the grounds for the AIFC Court's jurisdiction, it allows parties which are absolutely unrelated to the Astana International Financial Center to submit disputes to the AIFC court. For example, a Chinese company can enter into an agreement with, say, Uzbek company to submit their disputes to the AIFC court, and in that case, AIFC court would assume jurisdiction. AIFC court's judgment would be deemed automatically a judgment of the Kazakh court. So if the plan is to enforce something in Kazakhstan, AIFC court might be a good option. And in fact, it has proved to be a very important balancing tool when we enter into transactions with very influential local people. For example, if you're entering into a contract with a local oligarch, AIFC court is the place to go. And we have handled several disputes at the AFC court between local Kazakh oligarchs, and it's really changing the culture, because local oligarchs initially did not understand how the court works. And because of risk of open proceedings and cross-examination in open proceeding, they mostly settled their claims. So it's a very kind of training and teaching tool to locally important people. And it's a very good tool for foreigners if they want to obtain some powerful tools to basically neutralize the powers of the local influential people. So this is fairly it. If you have any questions, I'm ready to answer. I think it wasn't too quick.
Thank you very much, Bahit, for this wonderful summary, summarizing so many important aspects within a few minutes. I find several aspects very interesting and worthy of discussion. For instance, this jurisdiction AIFC and also the high enforcement rate. We can discuss it in more detail after our next presentation. And now we will turn our attention to Uzbekistan, and Diana, Director of the Tashkent International Arbitration Center. Please, the floor is yours.
Thank you very much, Dmitry, for the opportunity to speak and to see my dear colleagues from other Central Asian countries. The subject of today's webinar is centered around the topic of international arbitration in Central Asia, but obviously coming from Uzbekistan, I would like to share with all of you today what Uzbekistan has to offer in terms of access to alternative dispute resolution mechanisms and arbitration. Uzbekistan indeed has been making significant strides in recent years to put itself on the global map of international arbitration as an arbitration-friendly jurisdiction. There are largely three complementary but mutually reinforcing pillars upon which those reforms have been built. The first being the state-of-the-art legislative act modeled on and mirroring ancestral law and international commercial arbitration. The second being the establishment of the Tashkent International Arbitration Center at the Chamber of Commerce and Industry, or TIAC, as we frequently refer to the center. And third, reinforcing the status of an arbitration-friendly jurisdiction by having a supportive judiciary. And when it comes to the law itself, the new Uzbek International Arbitration Law that was adopted in 2021 is virtually the verbatim copy of the ancestral model law on international commercial arbitration. And we all know that the ancestral model arbitration law has not only been just drafted, but essentially crafted by leading international experts on arbitration worldwide. And this is now part of the legal framework governing alternative dispute resolution in Uzbekistan. TIAC was formally established in 2018, but launched in April 2019 during Paris Arbitration Week in Paris. And as coined by Global Arbitration Review, TIAC has the roster of 60 leading arbitrators and strict no conflict of interest rules that go further than the guidelines of the International Bar Association on conflicts of interest. I think this is an important point which I would want to emphasize, but this essentially means that not only the staff members of TIAC, but also the members of the Court of Arbitration, which is the only body within the structure of the center empowered to administer the case. So none of those individuals can act as arbitrators under the TIAC rules of arbitration. We've seen that in a lot of other institutions in the region, this was commonplace, where the staff members or chairman or members of the body that appoints arbitrators, that they have the ability to be appointed. We thought that this may create certain conflicts of interest, and from the inception, the decision was made that we would adopt the strictest rules when it comes to avoiding conflict of interest. These are essentially, there's 5 reasons why we think the users would choose TIAC. The first being the zero administrative fee. So we as an institution, we don't charge the fee to administer disputes. However, notably, our arbitrators that are being appointed to sit and act under the TIAC rules of arbitration, they get at times even more than they would receive in other leading institutions. And I'm talking not only about the CIS region, but also those institutions that are located in Europe, etc. We have the panel of TIAC, the panel of arbitrators has on its list the leading authorities in the field of arbitrators. So essentially, when we say that although the users have the ability to save on administrative fees, but they get access to the top class arbitrators, which are featured in the institutional memory of leading arbitral institutions, including ICSID, Permanent Court of Arbitration, etc. Third, as I mentioned, Uzbekistan is a non-citral model or jurisdiction. And I think this is very important to take into account when choosing the jurisdiction as well as the arbitral institution. The fourth reason is that TIAC has one of the most advanced rules of arbitration, and I remember having a number of sessions even with my other colleagues from institutions. In fact, they have referred to our rules as probably the most advanced rules, particularly because of the fact that we have a number of provisions that deal with administration of disputes in the field of advanced technologies. And we have separate opt-in cybersecurity rules also as an extra to the rules. And last but not least, there are certain exemptions on VAT, as well as certain tax incentives for the arbitrators. For example, those arbitrators that sit in cases administered by TIAC, they are exempted from a payment of the income tax. That's this. Very, very, very briefly, the latest statistics. We've administered nearly 60 requests for arbitration, 2 applications for emergency relief, 1 sport arbitration case, and relatively recently, first request for expert determination in connection with the project financed by the International Financial Institution. Parties or users of TIAC are quite diverse. You can see that they come from Italy, Netherlands, Turkey, China, Hong Kong, Kazakhstan, Russia, Bulgaria, and of course, Uzbekistan. And last but not least, in terms of statistics and caseload, in 2023, we've received the first request for arbitration where one of the parties to a dispute was the government of a country outside Central Asia and CIS. Probably another important development in 2020, for the first time in history, we've received the first request for arbitration where neither party was from Uzbekistan. The claimant was from a Russian Federation, and the respondent was from Singapore. In 2023, in September, during Uzbek Arbitration Week, we have launched a very unique and important initiative, and that is the TIAC HKIC cross-institutional rules of arbitration, under which two independent institutions, TIAC and HKIC, jointly administered cases. So we have been already receiving great feedback from the users from all over the world, asking for clarifications and standard arbitration clauses to include TIAC, HKIC cross-institutional rules. But I think this is definitely something that not only TIAC and HKIC can work together on, but also maybe that could be an example for other institutions to follow. I mean, as a framework, of course. In terms of the support from Uzbek courts, this is public information. There's been a number of cases enforced against Uzbek largest and state-owned companies, in addition to those that you can see on the screen. Relatively recently, again, this is public information, Global Arbitration Review has published an article about the enforcement of a foreign arbitral award. I believe that was Russian Arbitration Center against the largest oil and gas company in Uzbekistan, that is Uzbekneftgaz. And although there were certain arguments to use public policy grounds to set aside the award, interestingly, the Supreme Court has not interestingly, I mean, that this is part of the trend that was established long ago in Uzbekistan, but that was, and this is, in my opinion, the reinforcement of the Uzbek court's position on issues of enforcement. Yeah, this is another judgment that was issued to enforce a foreign arbitral award. I like to mention and to publicly announce this, but in my regular conversations with the representatives of the Supreme Court, we revisit this approach, I mean, towards public policy arguments, but they have been confirming this to me, and I had a conversation just 2 weeks ago again with the representative of the Supreme Court. They again have confirmed to me that there's not a single court judgment refusing enforcement of a foreign arbitral award on public policy grounds. Well, this is a very brief recap on Uzbekistan, but of course, I would be more than happy to answer any questions that you or the attendees may have in relation to Uzbekistan as a jurisdiction. Thank you.
Thank you very much, Diana, for the insights into the work of this emerging arbitral institution, which has, of course, been very visible over the few years. Most recently, and we shall wish further success and development to this, I think, very timely initiative. And thank you also for mentioning the good success rates and the good perspectives for enforcing of awards in the jurisdiction of Uzbekistan. Thank you all for the wonderful presentations. Let us look at the questions which we've received. There is one question by Mirbek Sidigaliev. Thank you, dear speakers, for interesting presentations. The question is, what are the main issues in each respective country and generally in Central Asia that are or could be a subject to international arbitration? Would anyone like to comment on this?
Ladies first.
Okay, maybe I will start. So if we will consider international arbitration from my perspective, from where I stand, the most proliferated issue for the arbitration is the improper performance of the contractual obligations. And as for Kyrgyzstan, it is, as a rule, as a sale and purchase contract, service and work agreement, and a lot of disputes based on the transportation agreement. So this is the main area for the international arbitration from the perspective of Kyrgyzstan.
It seems that the question relates to the scope of arbitrability in each respective country, as I understand it.
To be honest with you, I don't think that I understood the question, but maybe the person who asked the question maybe can provide some clarification.
Well, main issues which could be subject to international arbitration. So I guess it relates to what's the scope of issues which could be arbitrated. So, if I may, very quickly, under Kazakh domestic law, you could submit to arbitration, quote, civil law relations, unquote. So basically, anything which relates to some civil law character could be subject to arbitration. When it comes to International Arbitration Court of AIFC, because there is no statute which specifically identifies the scope of issues which could be arbitrable, I think it might be very broad, but I wouldn't still submit public law related disputes. So anything commercial, I think, should be fine.
Okay, thank you. We do have a raised hand. One of the participants would like to ask a question. Feel free to turn on your mic and to pose the question to the panel.
Good morning. It's morning in Botswana, Africa. Thank you, Diana, for such a beautiful presentation. I just wanted to ask such a quick question on the issue of enforcement. What mechanism do you have in place to ensure that foreign awards are enforced? Because it has proven to be a difficulty to enforce foreign awards. What mechanism do you have in place? Thank you.
Well, Uzbekistan is a party to the Convention, which and all the enforcements were obviously done under the framework of this convention. But in addition to that, an important development recently, which I would also like to bring to the attention of the audience today, is the establishment of the Tashkent International Commercial Court, which would be certainly now this is in discussions, but at least the latest draft of the law establishing Tashkent International Commercial Court refers to its exclusive powers to enforce TIAC administered dispute, TIAC administered awards, as well as other foreign arbitral awards. And when I say when I refer to Tashkent International Commercial Court, this is going to be the English language court with foreign judges sitting sitting in cases administered by the Tashkent International Commercial Court.
Thank you very much. We have two further questions. The first being, how does the costs for arbitrators in Central Asia compare with that of the UK or Singapore? Costs for arbitrators, so probably the fees for arbitrators and the costs associated with arbitration proceedings are meant. If you could please comment on the financial side of proceedings.
Ladies?
I'm just opening my slides so that you can see the comparative table, but if anyone else would like to...
Well, I can comment in the meantime. So we, as I said, we have two systems. If it's a arbitral institution which operates according to the Kazakh arbitration law, then they have their table of arbitrators' fees, and it's according to old model, like Soviet-style model, where you pay arbitration fee, and that fee includes arbitrators' fees. So, and it's usually within roughly 3% of the claimed amount, subject to a certain cap. In terms of International Arbitration Center of the AIFC, there is no such table. So there is an hourly rate of an arbitrator, and you are effectively are free to agree on whatever fee you can agree.
And just for reference, for your reference and for the reference of the audience, we have prepared some time ago the comparative table for a dispute with the value of $1 million US, and you can see that, for instance, in although in TIAC that there's no administrative fee, the arbitrator's fee are sometimes even higher, for example, than in the Stockholm Chamber of Commerce Arbitration Institute. But overall, we've concluded that the users save at least 30% on arbitration costs when they choose TIAC to administer this disputes. I hope that that was helpful.
Thank you, Diana. Another question is MED-ARB, mediation arbitration, as a mode of dispute resolution becoming popular in your jurisdictions?
Let me try to answer this question. Although we haven't yet administered any mediation, but we, again, given that we as an institution, we don't charge the administrative fee, our main objective is to provide the platform for the parties to resolve the dispute as quickly as possible. And in the course of discussions with the stakeholders, with the users, with the representatives of the law firms, we have agreed that we will be prompting the parties to explore mediation along or in parallel with the arbitration proceedings. We haven't yet had any agreement, so to say, although we've tried with one of the latest cases to offer mediation in the course of the arbitral proceedings. The parties have not yet agreed to that. So the trend is definitely there, but how parties would accept, I think we'll see that in the future.
I also want to add a couple of words. Of course, in Kyrgyzstan, we have such kind of opportunity, especially in the International Court of Arbitration. We have such kind of approach, mediation approach, and even the deputy chair of the International Arbitration Court, who is developed this dimension. But I don't see that it is very widespread in our jurisdiction. I know about 6 or just a little more cases when parties finally choose mediation and satisfied with the finality of the dispute resolution. But it's not in comparison with the total amount of arbitration cases, more than 1,500 of cases, 6 or 5 mediation cases is not a lot, I think.
Well, in terms of Kazakhstan, if it's under domestic law, then it's extremely rare. It's relatively increasingly popular at the Astana International Financial Center's IAC. So we hear about mediation as a step before arbitration more frequently.
Thank you very much for your comments. Another question concerns sports arbitration. And I will read out, it's a question by an anonymous participant. I would like to inquire, recently in the realm of arbitration, sports arbitration has been gaining traction, and always just wondering if there is any specific focus on in Central Asia to develop or promote sports arbitration and sports-specific arbitration rules. Are you aware of any such developments in your country?
Well, I can only say that we've administered one sport arbitration case, and we've also been given the exclusive mandate to be the service provider for the Tashkent International Marathon World Athletics label race back in 2021, I believe, or 2022. Since then, we regularly work with various federations to promote TIAC as a forum to resolve disputes. I must say that it's going to be an interesting journey. But at the same time, definitely there's a lot happening in the field of in the sports industry, and there's definitely a potential for a lot of disputes administered by arbitral institutions.
Haven't heard. We don't do sports law, so maybe not. I'm not the right person to answer the question for Kazakhstan.
Okay, thank you. Another question would be to you, Bahid. You've mentioned the Astana International Finance Center and its own rules and its own legal regime. Can we understand it as a kind of a jurisdiction within a jurisdiction? And are you aware why English law has been chosen? Is it because some other model was copied? Because at first sight it appears unusual, Kazakhstan being a civil law country, while English law is, as we all know, a part of the common law world.
Well, as I said, we like copying things. So I don't understand. I don't know if there was really some deep understanding as to why it should be English law. My understanding is that people liked how DIFC worked, so they just decided to copy it, and it proved effective. Particularly in our courts, where administrative influence by the state is not uncommon. So it has proved very effective. So and it is in fact a jurisdiction within jurisdiction. There are many issues which arise in practice in terms of interrelation between the local courts and the English court. For example, things like res judicata effect of judgments, back and forth, and all of those things. I think our firm we're probably doing the largest number of AIFC disputes at this moment, if I'm not mistaken. And it's a very exciting place to be compared to domestic court. So I very much recommend everyone, if you're doing anything which relates to enforcement in Kazakhstan, please do come to AIFC court.
Thank you. I have a question to Diana. You mentioned this interesting initiative of collaboration between two well-known institutions, TIAC and HKIAC in Hong Kong. Could you please explain us in a few sentences how the collaboration, how those cross-institutional rules are supposed to work, and whether it is an exclusive project or whether you can imagine having similar projects with different institutions, be it in Asia or elsewhere?
I knew the question would be coming, so this is a very brief slide to give you some recap or the summary of the framework. Yes, indeed, that probably this is one of the first and the only framework that exists to date, under which two independent institutions jointly administer the cases. As you can see, certain functions such as the decision on the appointment of arbitrators, determination on the challenges to arbitrators, determination on the requests for consolidation, request for joinder of additional parties, as well as the scrutiny of the awards, will be performed by the HKIAC. But other functions, such as, for example, registering the request for arbitration, communication with the parties in the tribunal and sending the first correspondence, collecting demand and managing deposits and extending the time limits, will be performed by Tashkent International Arbitration Center. It is an exclusive arrangement. This was decided by HKIAC and TIAC at the very beginning, although it is very interesting, in my view, operational framework. But at the same time, I do feel that other institutions may be able to cross fertilize our experience and potentially apply a similar framework to their operations.
Thank you, Diana. Natalia, you mentioned that under Kyrgyz law, there is currently no opportunity to set aside, to apply for setting aside of an award, but there is a draft law which is supposed to allow it. What's your personal opinion on that? To me, it seems to be rather unusual. I'm not aware of any other jurisdictions which do not have a setting aside procedure. Do you think it should be implemented?
Yes, Dmitry, thank you very much for your question. Yeah, you know that I believe that we only jurisdiction where there is no such kind of procedure. Latvia was the last one, but a couple of years ago, the Constitutional Court recognized this provision unconstitutional. So we are the only jurisdiction where there is no such kind of procedure. If you want to know my personal perception of the situation, as I explained in the presentation, I understand why it was abolished from the initial law on arbitration, because from the perspective of the initiators, it was important at the beginning of the 2000 to support the arbitration in our country. So the absolute finality of the arbitration awards was a privilege at that moment. But after the 20 years of experience, I understand that there could be situation when the losing party need to have an effective right to protect themselves, because if the winning party doesn't apply for the enforcement of the arbitral award, losing party doesn't have any effective rights to protect themselves against the abuse in arbitration procedure or any infringement of arbitration procedure. And additionally, the absence of setting aside procedure gave rise to the destructive practice in Kyrgyzstan, where the losing party, out of desperation, began to bring claim to court to challenge the action of the arbitral institution as a legal entity, or claims to recognize the legal fact that the arbitral institution have taken an award on a dispute that is not covered by the contract. Of course, this is the wrong practice, but the losing party sometimes had to be creative to obtain the right to be heard. So to my mind, we need setting aside procedure, but maybe we need to help our government, to our Ministry of Justice to create the more effective draft of law in order to provide guarantee for both parties to protect the finality of arbitral award, and at the same time to provide the losing party the effective right to protect themselves in case of the abusive arbitration procedure.
Thank you. I have a following question to all of the panelists. You've mentioned the positive statistics when it comes to enforcement of awards. Is it possible to say which grounds for refusal the opposing party usually relies upon? Is it public policy consideration? Is it proper notification? Is there a kind of a trend or a typical case?
Well, as ladies are thinking, I could mention probably most popular ground is lack of notification. So basically failure to properly notify. We've heard several times failure to properly present a case. For example, lack of understanding the language, or maybe failure to be able to present for communications reasons, whatever the ground. A couple of cases where it related to alleged environmental issues, and it was argued that it constitutes public policy, but it was rejected. So maybe this is it.
Okay, if I may add, as for Kyrgyzstan, we also the most common. So it's not a lot of cases when the state courts refuse the enforcement of foreign arbitration award, but the most popular ground, I agree with Bakrit, is the failure of notification of one of the parties. We have no practice concerning the public policy at all, so no any cases. Very rare cases when when the court refuse to implement the arbitral award based on the incorrect formation of the arbitral tribunal, or when the arbitral tribunal went beyond the scope of the arbitral agreement. But I wouldn't say that this has reaches so alarming. This is the alarming situation in Kyrgyzstan. So it's rather rare cases.
Okay, thank you. And a brief question on the Diana, would you like to add something?
I wanted to add that it's similar in Uzbekistan, and one of the common ground that was that you can see for the refusal of the enforcement is.
Thank you. And a brief question on the choice of arbitrators. If we look at the statistics of prominent arbitral institutions, there is quite a discrepancy between the number of parties, so companies participating in proceedings, and the number of arbitrators appointed from your jurisdictions. What could be, I think, so there are far more parties than arbitrators. What do you think could be the reasons for that? And do you expect it to change over the coming years?
Ladies?
This is definitely the area that TIAC works extensively on, and we have on numerous occasions publicly announced that we will be working closely with the local and regional arbitration practitioners to help them get their first appointments. We've included into our form and the format of the CV that a prospective candidate to the panel needs to fill out the column about the shadow arbitrator appointments, and I think this is an important initiative wherein those younger or those practitioners that haven't had yet the opportunity to get to get their first appointment, they can act as observers in TIAC administered arbitrations upon written consent of claimant as well as the respondent. So that's an important project. We work closely with a number of practitioners in the region, and we do want to expand the pool of arbitrators for TIAC administered arbitrations, because definitely, as you rightly point.
I agree with Diana, and I think that this is the only way how to enhance the participation of our local specialists as arbitrators in the international market. I think that the most lesson learned which Kyrgyzstan has after this huge amount of international arbitration, both commercial and investment, that we need to develop our local specialists in arbitration. We need to reduce our dependency from the legal international law firm. But I believe that the practitioners who want to be focused on arbitration also need to be more active, need to visualize the activity more clearly in order to be chosen by the parties.
Well, I think the question was why the number of arbitrators from the region is not large in international arbitration institutions. I think there are two answers to that question. The first answer is, well, with all due respect, I personally don't believe that international commercial arbitration is some rocket science which only Western lawyers know and they only can do this. I mean, come on, we can draft the same texts, we can speak in the same way. I participated in a number of arbitration proceedings where you could barely understand what the council is saying in international arbitration proceedings. So I think maybe there is this stigma with international arbitration institutions in the West that they should not consider local arbitrators, local lawyers as those who could be admitted and act as arbitrators. And only exceptional individuals like Natalia maybe have the privilege of really being appointed, for example, by ICC and others. So I think what could be done is in arbitration institutions in the West should probably start reconsidering their approaches to appointing people from this jurisdiction. And I think we should be more active in terms of promoting us as well. And the second reason, I think local, well, at least as for Kazakhstan, what I can speak of is that we have a lot of money in this country, right? And everyone is busy. So, it looks like there's so much work to do in the legal market. And that's why maybe people are not considering very seriously doing international arbitration work just because there's so much things to do. Particularly in the last 2 years. So maybe we just need to wait until the number of lawyers is increased and then there's more interest towards international arbitration. Maybe you will disagree, but that's my guess.
Okay, thank you very much. We have one remaining question in the chat box. An anonymous participant is asking us to comment on Gonzalo Stampa's recent contempt of court conviction by a Spanish court, specifically in relation to arbitrators' immunity. What are the repercussions for the accountability and independence of arbitrator? So it concerns liability and immunity for arbitrators. Would anyone like to comment on immunity provisions and practice in your jurisdiction? I admit it's a rather question which comes up rarely. Have there been any such cases in your jurisdictions, maybe, which have reached the press?
Well, we all know the famous cases and famous developments in the Middle East. What happened a few years ago, when Dubai and I think then Qatar introduced criminal provisions and criminal liability for arbitrators, and this is when a lot of arbitrators simply declined to accept any appointments. That was the time when the working group was established in Uzbekistan to draft the new law in international commercial arbitration. And again, given these developments and the fact that we did not want that to happen, we have a specific provision in the law that grants immunity to arbitrators as well as experts. And it is part of the law, and I think this is one of those very few additional provisions that were introduced into the model ancestral law.
In Kyrgyzstan, we also do not have any cases like this, but I remember when the draft law about the tax arbitration was introduced, there was additional amendment to the criminal code about the criminal liability of the arbitrators for their decisions. This provision was very much critiqued by the arbitration community and didn't come to the final version of the draft law. But I remember such initiatives was a couple of years ago.
Well, in terms of Kazakhstan, I was thinking as colleagues were speaking, I cannot think of a provision in the criminal code which would really hold an arbitrator liable for something like that. So if anyone wants to do a big arbitration in Kazakhstan, please do come. I think you guys are not going to be liable criminally in our country.
Thank you. And we're slowly running out of time, but maybe as a final question, we've mentioned that Central Asia is not only interesting in terms of commercial arbitration, but also investment arbitration. The countries have produced some case law, and if we look at the exit case database, we will discover some cases with countries from the region being respondent. Is it possible to briefly summarize what the cases were about? Do you have maybe a forecast for the future, whether the number of such investor treaty cases or investor state cases might increase?
In terms of Kyrgyzstan, you know that we have a number of investment cases in Kyrgyzstan. At least most memorable from the last period of time, it's the Panvel case, it's the Rusgidro, Kyrgyzstan against Rusgidro, and very sensitive case between Kyrgyzstan and Uzbekistan concerning the Isyk-Kul resorts. Most of the cases were about the fair and equitable treatment and about the proper and improper expropriation. And of course, after this number of cases, we have a lot to think over. I mean, for instance, I believe that we need to think about the improvement of negotiation between the parties. Maybe this is the way to decrease the amount of cases. And based on these lessons which Kyrgyzstan learned, during the last year, we developed this special procedure for investments which can complain before the arbitration to the investment authority about their future claim, maybe. And this investment authority will check your claim not based only on the legal ground, but also based on the economical risk, and provide the comments for the government about the perspective of this future case. I think that's a good mechanism to decrease the pressure to the government. And this is one of the lessons learned by the Kyrgyzstan from this huge amount of investment cases. Maybe another insight is our dependence of these cases on the poor quality of our legislation. Even the discrepancy between the Kyrgyz and Russian version of the text, even the improper implementation of terms can finally lead to the investment arbitration. So we need to pay our attention to the improvement of legislation. And of course, corruption. I know that in most of these cases, corruption was like a strategy for the Kyrgyzstan how to protect themselves from the investment arbitration. But I see that this also have a negative effect for our country. It doesn't work anymore. Kyrgyzstan also has a negative consequences of the corruption in Kyrgyzstan. So this is my insight from this situation.
Well, in terms of Kazakhstan, if some of you are unaware, since 2019 and 2020, our government, which ruled for 30 years, has changed. So it has become our client. We call it the old Kazakhstan. So the guys who ruled for 30 years now are trying to save their assets, and the new government is trying to take them. So I think Kazakhstan will generate a lot of investment treaty disputes. We are already working on our new unexplained wealth law. And that's going to generate a lot of activity maybe in the next 2-3 years. Traditionally, Kazakhstan has been very popular for investment treaty claims, mostly arising out of natural resources and hydrocarbons. We've been also active in English High Court. In fact, there's a separate body of Kazakh law developed by English judges interpreting how Kazakh civil law should be applied. And I think the same trend is going to happen with the Astana International Financial Centers Court. So there will be a separate division of local law in the English interpretation. So that's it.
From my side, Uzbekistan was the respondent in a number of investment disputes and exit. I think this is that's not surprising. And we also say that when trade and investment are on the rise, disputes will inevitably rise. So given the activity and a very active investments. And a lot of the relationships and the trade relationships, business relationships are growing. So disputes will inevitably arise. And drawing on successful experience of certain Latin American states and Peru in particular, there were discussions with the government to create the dispute avoidance committee, just like in Kyrgyzstan, to essentially review and provide the opinion as well as certain assistance to the parties prior to the actual dispute settlement procedure. That's briefly.
Thanks very much. There are no further questions in the chat box, and I think we've covered so many topics already. Is there anything else you would like to add as a kind of a final statement? If there is nothing, let us then thank all the speakers for their wonderful contributions, very informative, covering lots of aspects, all the practical and topical issues. Thank you to the audience for joining us and actively participating. That should be it for this webinar, and we shall look forward to upcoming activities and events of the Asian Institute of ADR. Thank you very much to all.
Thanks, everyone.
Thank you so much, Ms. Moderator and honored speakers, for the engaging session. Dear participants, we hope you enjoy this webinar on international arbitration in Central Asia and gain some unique insights. Before we end, we would like to kindly invite the speakers and moderator for a short photography session.
Sure.
Okay, 3, 2, 1. Thank you.
Thank you so much. Hope everyone has a great weekend ahead.
Thank you, Dmitry, for
Thank you.
fantastic moderation. Diana, Bakrit, Kinsley, thank you very much. It was a real pleasure for me to take a part in this event.
Thanks.
Thank you. Bye.